So you've been in a car accident and your attorney has gotten you a financial recovery. And they say, now we're going to take out our attorney's fees and we also have to pay liens. We have to pay back medical providers, including your health insurance. And most people think that that is unfair. And I particularly agree, because I think you pay for your health insurance and you shouldn't have to pay them back. But that's not the law. So an attorney is obliged and required to pay back a lien. If they don't do that and they leave that on the client's going to get sued later. So I think that there's an ethical obligation to take care of liens, people that have a valid lien. So what is a lien? You all know what a lien is on your house, right? You build a house and the bricklayer comes and puts the bricks in, and you get the house, but the bricklayer was never paid by the general contractor, and now there's a lien on your home, and they're seeking to recover money. It's the same thing on your injury case. You go and you get $100,000 worth of medical care, and I get your case resolved for $1 million, and now the health insurer wants their $100,000 back. So what do? You got to fight that lien, and there's a lot of ways to fight it. The first thing is you got to read the contract. What is that insurance company relying upon to get their money back? And you've heard this a lot. The ERISA lien, that's the Employee Retirement Security Act of 1974. And so they say, we're an ERISA lien, you've got to pay us back. And that may be true, and it may not be true. The first thing you got to do is read the contract and see if it's a self-funded plan. If it's a self-funded plan, you're probably going to have to pay them back. Then my next suggestion is negotiate with them professionally and with courtesy, because you catch more flies with honey than you do with vinegar, and a lot of this is discretionary. But if it's an insured plan, an ERISA insured plan, then state law applies, and you can look at Missouri's remedies to adjudicate those liens, meaning go to court. You can say that it's not a fair recovery, it's not a just recovery, the client's not made whole, there's lost wages that aren't compensated for, and therefore the amount of money, we shouldn't have to pay you $100,000 back because Cantor charged me 30, and so we should reduce the amount. And that works. You should narrow the claim and reduce the claim. So if you have unrelated charges, if you hurt your neck in a car accident, you had a neck fusion, but you also had the flu, and there's some charges for the flu that were 2 months later, you should say, wait, those aren't related, and you should negotiate those. You should reduce the claim. You should say, wait a minute, those weren't fair and reasonable charges. So, the hospital billed that amount. We all know that these hospital bills are ridiculous. We should negotiate that that's not the fair and reasonable charge. But I think the most important thing I said there is use common sense and courtesy and be an advocate for your client. There are other types of liens. There's workers' compensation liens, and I wrote an article on that called Workers' Compensation Subrogation. So you're in a car accident at work, you recover your workers' compensation, you get your medical, you get your lost wages, and you get a lump sum payment, and now you settle your civil case, and all of a sudden the work comp people want all their money back. Well, they're not entitled to get their money back entirely, and that's not actually, in Missouri, that's not a lien, that's called a subrogation interest. It's different, but they still have a right to what I call reimbursement. They have a right to get repaid. The formula is Rudiger. I've written an article on that. It'll bore you, but you can read it if you want. I can make that available to you. There's also Medicare and Medicaid liens. Those liens have to be dealt with. My staff does it all the time. We go to the Medicare portal and we see what's been paid and what's owed back. And you've got to deal with the federal government, and you've got to deal with the state government, Medicaid. And if you don't deal with those, Uncle Sam's coming at you. Okay. There's also a direct lien. So maybe you don't have money to get medical care, and you go to a medical provider and you sign a lien and you say, I promise you, medical provider, I'll pay you at the end of my case. Well, that's a valid promise, and you've got to pay it back. It's also a valid lien. But there's something in Missouri called the lien statute. You only have to pay back half the disposable amount after attorney fees and costs. So if you, in my example, if you have $100 worth of medical and you recover $150 from your case because there were some bad facts or whatever the case is, you wouldn't want to pay $50 in attorney fees and $100 for medical. That would leave you nothing. In my example there, you pay your prorated share. So $150, you pay the attorney $50, you pay the providers $50, and you get $50. That's half the disposable amount, because after attorney fees and costs would be $100. You split that. That's what the Missouri lien statute says. And so I know that if there's a lien in Missouri, you're going to get half the amount that's left after attorney fees and costs. So I've told you a lot of things here. You know, you've got to deal with this. This is a big part of the case. So a good personal injury lawyer, they're not just looking at the total recovery in lump sum, they're looking at the amount that you get after paying back all these people that have a right to reimbursement or liens. I'm Mark Cantor. If you have a case and you need assistance from the beginning all the way through the end, including lien repayment and reimbursement, call me, 314-628-9999. Thank you.